Thank you everyone for joining us this afternoon. Really excited for this event on protesting deportations from the Stansted 15 to the Jamaica 50. Just some housekeeping to begin with. Firstly, you've been placed on mute, so please post any questions that you have in the Q&A window. The chat function is enabled for any other comments, queries and or feedback, but don't post questions in the chat function because they may get lost. So please use the Q&A box. Secondly, any resources will be circulated to registered delegates after the webinar. Thirdly, this webinar is being recorded. So what that means is the audio and video of the panelists and anyone who speaks, if they're unmuted, will be recorded. This webinar also might be shared on Garden Court's marketing channels, including our website and social media. And lastly, please refer to the instructions in the chat window if you're experiencing any technical difficulties, and we'll do our best to help you. So I'm very excited to have such a brilliant panel of absolute experts with us today, experts in the courts and on the front lines. And I just thought I'd set out some context for the topic today. So as many of you will know, in 2007, New Labour implemented the law which permitted the deportation of people who've been sentenced to 12 months or more in prison. And they've since shielded from holding the government to account for successively and increasingly racist immigration policies. Up to 2,000 people a year are loaded onto secretive flights at night, often shackled in restraints and subject to force by private security escorts. And in the absence of robust political opposition, it's been left to activists and lawyers to challenge these practices. It's important to acknowledge, however, the limitations of litigation in an inherently racist immigration system in dismantling the framework that legitimizes deportations. So whilst lawyers do crucial work in representing people through deport appeals or seeking injunctions to prevent deportations, the political pressure has been mounted and solidarity efforts have been fought by protesters on the streets and through direct actions. And crucially, in 2017, the Stansted 15 famously stopped a deportation flight, which was due to deport 60 migrants to Ghana, Nigeria, and Sierra Leone. And of the 60 people who were to be forcibly removed, 11 have now regularized their immigration status in the UK. The Stansted 15 were, however, arrested and endured a 10-week trial for their actions, and they were ultimately convicted of terrorism-related charges. The New Statesman has called it the most important political trial of our times. Just last month, however, their convictions were overturned on appeal, and the Court of Appeal said that there was in reality no case to answer. However, the treatment of the Stansted 15, despite the brilliant outcome last month, has made it more difficult for protesters to resist deportations through direct actions. The heavy arm of the state remains a deterrent, and the response to dissidents includes heightened police presence at airports, airport bylaws that ban protests, and the punitive treatment of demonstrators in our civil and criminal courts. And so this serves to stifle the right to protest and prevents racist deportations from being challenged by the public. However, we have continued to see protests and campaigns against deportations hard fought. In February 2020, BAME Lawyers for Justice staged a protest against a planned charter flight to Jamaica outside Downing Street. In June 2020, Black Lives Matter protesters in Brighton and Hove protested outside the British Airways I-360, opposing their involvement in deportations and their complicity in the death of Jimmy Mbenga. And just a few months ago, in December 2020, Barrack UK and Movement for Justice led a campaign against a charter flight that was due to go to Jamaica with 50 people on board. And that particular campaign saw a huge amount of mobilization through the use of public figures, rights groups, lawyers, and politicians. Eventually, a deal was agreed between the Home Office and Jamaica in secret to not remove people from the UK who came here as children. And as a result of huge legal efforts, including by many at Garden Court Chambers, several of the men on board were taken off the charter flight just hours before it was due to leave. But we know that attempts to resist this charter flight through direct action was met by stringent police controls at the airport, and therefore 13 people, among them fathers of children in the UK, were still forcibly removed. So the question we're really examining today is, what space is there left to protest deportations, and how has this changed over recent years from the Stansted 15 to the Jamaica 50? Mobilization campaigns and protests are vital in raising public consciousness of state racism, challenging the actions of companies who are complicit in deportations, such as airlines and G4S, and do increase political pressure. Legal action can secure reprieve and urgent assistance for people facing forced removal. And direct actions, as we've seen with the Stansted 15, can stop a plane from leaving altogether. But within a hostile environment for migrants and migrants' rights activists, and the limitations imposed and inherent in all of these spaces, how can we meaningfully work together to both protest and defend the right to protest deportations? And I think a helpful way to just frame this discussion is a group of academics at the Peace Research Institute in Frankfurt have found that there are 4 factors that contribute to a successful protest against deportations. The first is public preference, i.e. creating pressure through public opinion that helps convince stakeholders and decision makers. The second is political access. The third is judicial means. And the fourth is disruption through civil disobedience. And we're very lucky that our speakers today have played parts at all of these levels. And so I'm really excited to hear from them on the immigration context, protecting protesters in civil and criminal courts, and how we should all build collective resistance going forwards. So we're going to start the discussion today with Stephanie Harrison QC from Garden Court Chambers. Stephanie is a leading public law practitioner and joint head of Garden Court Chambers. Her multidisciplinary practice spans the breadth of public law and civil liberties, including the civil right to protest and protest injunctions. Her expertise also spans the areas of deprivation and refusals to citizenship and naturalization, fresh and certified claims for asylum, detention and conditions of detention, challenges to deportation, and cases involving national security. Stephanie frequently appears in the highest courts in landmark cases, particularly test case litigation, and she's been instrumental in winning some of the most important cases within her areas of specialism. So Stephanie, I'll hand over to you. Thank you so much.
Thank you very much, Zara. I think I wanted to set some of the context from my own experience over the last 30 years. I don't know how it's got to 30 years, but it has, of the way in which immigration legal cases are always set in the context of campaigns. And for some people, especially if you're not familiar with the area, it may come as a surprise that you do have a situation where some of the most marginalized people in our society, those who are seeking asylum, migrants, who are vilified in the press and appear to be pariahs in our society, in fact, have a wide range of support that is generated through legal campaigning and other community organizations. And I think it's very important to start from that premise, because it's very easy for the government to paint asylum seekers, migrants as others, as outsiders. And it's an important part of the work that we do to make clear that that there is a strong well of support within communities and across communities for a humane and respectful immigration policy and practice. And where I wanted to start was with a quote from a book that was written in 2012 by a barrister at Garden Court Chambers who retired in 2012, Frances Webber. So she spent, similar to me now, 30 odd years working in the field. And she wrote a book called Borderline Justice, The Fight for Refugee and Migrant Rights. And in the introduction to that book by Gareth Pearce, Gareth identified what was described in this book. And what she said was that the book is a record in disturbing detail of a pitched battle from the perspective of those entitled, almost all voiceless, vulnerable and powerless, struggling for even the most minimal recognition that the same justice should apply to us all. And so in that context, when one is looking how this group of people who are marginalized do have a voice and do exert power and agency, one cannot look at those questions without seeing the connections and the campaigns that have formed around the very many different ways in which the British state has sought to curtail rights, to introduce a network and an extensive state apparatus of control, and particularly focusing on enforcement, detention, and deportation. And what's interesting, if one looks at Frances's book, and I recommend to all of you to do that, is that while she documents over the decades a sequence of increasingly restrictive and draconian steps that have been taken by the government to curtail rights and enforce harsh immigration laws, she also documents how alongside each one of those developments is both a legal campaign or legal action to challenge those measures, as well as local campaigns. So that if you read through her book, what you find is that for every action, whether it's denial of benefits, which was a big issue that occurred in the 1990s, you find that there is a campaign, first of all, spearheaded by the Joint Council for Welfare of Immigrants, backed up by other relevant organizations identifying the impact, that the obvious draconian impact of such a measure. And there's a legal case that sought to challenge those regulations and was successful in declaring them to be ultra vires. Similarly, if you look at the increasing use of detention, you will find legal cases that have been brought and have been successful to some extent in seeking to hold to account and to expose some of the most extreme abuses of the power to detain. And you have a plethora of organizations that are involved in campaigns, whether that's the Refugee and Detention Action organizations. Every detention center has a local campaign which is set up to close that, whether it's Campsfield or Yarlswood or Brookhouse or Harmondsworth. Each detention center has a local organization that springs up alongside to act in solidarity to say this place needs to be closed because it's inhumane and wrong to detain asylum seekers and migrants. Similarly, in the context of detention, you have organizations that have focused on vulnerable detainees, whether that be those with mental illness, lacking capacity, or other forms of serious illness who find themselves in detention, usually in breach of policy. And you have Medical Justice, Freedom from Torture, the Helen Bamber Foundation. And those organizations represent a wide spread of groups of volunteers and others who raise money and who campaign in respect of those issues. Many organizations have sprung up around the position for women who are detained, whether that be Refugee Women's Action or Women for Refugee Women, and they are involved in extensive campaigning, lobbying, engaging in publicity to generate interest in those groups. And so one can see that at every turn, however oppressive the actions of the government are, there is always a campaign. That campaign will be both focusing on legal cases, on wider lobbying, and raising awareness amongst local people, and providing along with it actual practical support for individuals, so that in the campaign to close Campsfield, for example, those local people set up a choir and they go into the detention centre and they provide support, they provide means of communications with family members, clothes, and social and psychological support. So it is a network. In some respects, one can say, well, that's ameliorating these oppressive measures. But for those individuals who are isolated and in detention, knowing that there are people in this country who do say, we want you to be here, we welcome you, is a vital aspect of what they do. Most recently, and perhaps typical of this sort of experience, is what's happening in two camps, which I don't know if people are familiar with it, but in September, the government began to use ex-military bases to accommodate asylum seekers and those who are facing removal. It was an extraordinary step to use as a form of accommodation military bases for migrants and asylum seekers. And it immediately resulted in local campaigns being set up in Penally, which is in a remote part of Wales. The local residents set up a campaign called Penally Campaigning Together support group, and the local Stand Up for Racism organisation got involved in organising support and in protesting against far-right extremism, which was generated by the use of this camp, who were themselves organising extensive protests. Similarly, in Napier, another military camp used in Kent, the Kent Refugee Action Network came immediately into action in terms of raising awareness, opposition, practical support, and they were supported by the Care for Calais organisation as well. And they do this, each of those groups has a similar function. It's about resistance. It's about holding to account the government for this measure through local campaigns, through media engagement, and also providing practical support, because there's no question that there's a humanitarian crisis occurring in those camps. Individuals don't have sufficient food, they don't have sufficient clothes, and that gap is being met by these campaigning groups. One element of this development, which is a challenge and is a new development, is the fact that far-right extremists are using the use of these camps as a focal point for their own form of protest, which has resulted in protest and counter-protest. And whilst we, of course, here are talking about how we might support through campaigns and protests the rights, fundamental rights of asylum seekers and migrants, and to resist deportation, we do now have the spectre that the far right is using direct action tactics to foster the alternative approach. So the context of the use of these camps was an orchestrated campaign triggered by Nigel Farage to oppose the use of hotels as a means of accommodating asylum seekers and others. That led to far-right activists picketing outside hotels, harassing people who were leaving. And in direct response to that, the government chose to choose this form of unacceptable accommodation, expressly a less generous form of accommodation to directly respond to the opposition to any form of accommodation for asylum seekers. That backfired, and in fact the use of these camps then became a focal point for large protests on a regular basis, as well as daily harassment, intimidation, and abuse, racist abuse, overt racist, Islamophobic abuse of asylum seekers and others in the camp, so that they were unable to even leave this camp. And so I think that whilst we have to focus on, and you're going to hear from other speakers about how we do use these rights to give voice to the voiceless and to bring some power to those who are otherwise made powerless by oppressive laws, we also have to be cognizant of the fact that those same techniques may be used by forces that are not progressive and don't have the same interests at heart. And I'd be interested to see what people might make of that.
Brilliant. Thank you so much, Stephanie, for that insight and overview. And given what Stephanie said about the use of a combination of sort of legal strategy in defending protesters and campaigns, and the rights of activists as well. We're now going to hear from Raj Chadha. Raj is the head of the criminal department at Hodge Jones and Allen, and he specialises in protest law. He is one of the country's leading criminal lawyers and described in the Legal 500 as a leader in the field of protester work. He represented the Stansted 15 throughout their proceedings, as well as countless other anti-deportation campaigns. He also won Criminal Lawyer of the Year at the Legal Aid Lawyer of the Year Awards in 2012, and was commended in 2017 as Advocate of the Year. So really grateful to have you here, Raj, and looking forward to hearing from you.
Thank you very much, and really pleased to be here and to hear from all the speakers tonight, and from the questions that no doubt will follow. I'm going to talk about the Stansted 15 and some of the legal issues that came up in that case. But before I do, again, I think it's worth putting in context what we're really discussing, because the greatest shame possibly for successive governments is how it has treated migrants and the public discourse about immigration and asylum. In 2021, I think the fight for justice and the fight to be treated with respect in the UK begins with how we treat migrants. And if that sounds personal, that's because it is. And I look at the panel and those that have attended today, these are laws or these are policies that would affect our parents, our grandparents, and that we wouldn't be here otherwise. And it affects individuals, and it affects how public policy has been altered. The hostile environment, even how the Brexit debate was conducted, and about our asylum system. There is a famous exhibition in the Jewish Museum in Camden, which puts Daily Mail headlines in the 30s, from the 1930s, about Jews coming to the UK, next to Daily Mail headlines about asylum seekers coming to the UK in the 2000s. And you cannot tell the headlines apart. And that is a reminder as to what this is all about. And it's basically that the state has failed. The state has failed to provide anything like a fair immigration system, failed to provide leadership about how migrants should be treated, and it fails to comply with basic international standards and fundamental duties to these individuals. And it's within that context you enter the Stansted 15. And Ben will speak more about what they did and why they did it. But you've already heard they blocked a charter flight that was in a remote part of an airport, in effect in a plane parking lot, because they were concerned that the people that were on that plane would be deported and would be at real risk of death and serious injury. In terms of what happened, after the action, the defendants were charged with fairly minor public order offences: aggravated trespass, criminal damage to the fence, and various non-imprisonable bylaws, airport bylaws. And that's normal stuff. I've done a number of these airport actions, and that's the pretty standard response from the state as to these actions. And I remember sort of within the first couple of weeks after the action, going to the first appearance in the magistrates' court. And for those of you that don't do criminal law, you get a summary of the prosecution evidence in a little pack, and sometimes they put anticipated plea. And the CPS lawyer that we reviewed it at that time had put anticipated plea guilty, and they had expected the whole case to finish there and then in May 2017. Well, needless to say, the clients didn't plead guilty. And the shocking thing, though, was, as everyone knows, 3 months later, someone, somewhere in the CPS, decided that those charges weren't good enough. They changed the charge to an offence contrary to Section 12B of the Aviation and Maritime Securities Act 1990, endangering safety at an aerodrome. Well, what did that mean for the defendants? It meant that aggravated trespass, which had a 3-month maximum prison sentence, was changed to endangering safety at a public aerodrome, which maximum sentence was life imprisonment. No change in conduct, just a change of mind from somebody in the CPS. Attorney General consent is required for this prosecution, and it was duly granted. What is this offence? Well, it is a serious offence. It's a specified offence under the Criminal Justice Act, so it attracts the provisions of being a dangerous offender. It is a convention offence for the purposes of Schedule 1 of the Terrorism Act. What that means is that it would be an offence to publish a statement to encourage the commission of an offence like the Stansted 15, and you can get 7 years prison for it. So it could be arguable that had their conviction not be overturned, those at Garden Court that have kindly agreed to host this would be facing a potential prison sentence of 7 years. It's an offence of universal jurisdiction, which means that conduct anywhere in the world could be prosecuted here. And it implemented something called the Montreal Protocol, which was an international agreement about combating terrorism. And that came into being because of a series of hijackings in the 1980s, such as those of you that can remember the Achille Lauro hijack and other terrorism offences at airports. And the UK Act came shortly into existence after Lockerbie. So this is high-level stuff. This is meant to deal with really high-level terrorist, in effect, offending. It has to be committed by means of a device or a substance. And one would think, when you look at that background, it would have to be inherently dangerous, and that it would affect the aerodrome as a whole. Yet that's not how it was prosecuted in the Crown Court. Despite having charged this offence, the prosecution prosecuted it because they know the only way they could secure convictions was as if it was a health and safety matter, that it was inherently dangerous because there were people in this remote part of the aerodrome, that lights were used, that the device that you require for the legislation doesn't need to be inherently dangerous. It can just be a tripod. It can be the lock-ons. That the danger is the fact that police had to come to deal with you, and so they down arms from the main terminal building. And they even spent an inordinate time during the trial raising the issues of the health and safety manual at Stansted Airport and cross-examining the defendants that they had, whether they'd done a risk assessment before conducting their actions in accordance with the health and safety manual. And so they prosecuted it as if, as I say, it was a health and safety prosecution. And the prosecution's primary submission on that point was that it wasn't really a terrorist offence. Don't worry about those issues. So that, in a way, gives rise to the levels that the state will take to punish some of these individuals. So the idea that it wasn't anything to do with the Montreal Protocol, I just want to read to you the introduction to the Act. This is an Act that gives effect to the Montreal Protocol of the suppression of unlawful acts of violence at airports. Yet, prosecution counsel did stand up in court and say, well, but this part of the Aviation and Maritime Securities Act, that's nothing to do with the Montreal Protocol. We had the Hansard debates, where it said that the minister introducing the Act said that one of the hallmarks of this government has been the determination to stand firm against terrorism. We will never shield away from measures necessary to crush the threat of terrorism, be it in an international stage or at home. This bill will be another valuable weapon in the battle. It will help combat international terrorism, and so on. And, you know, what they said was this clause 1 will deal essentially with terrorist acts at airports. What it dealt with were 15 individuals who laid down, tried to make sure that a plane deporting people did not take off. And those 15 people, as Ben reminded me shortly before this meeting started, were singing various songs such as Beyonce. And that is what the Crown said constituted terrorism offences. Now, thankfully, the Court of Appeal agreed with our interpretation, and that this was an act that should never have been used against these defendants. But it is troubling that it was used in the first place, that the CPS thought that it was appropriate, that the Attorney General, a Tory cabinet minister, Jeremy Wright, consented to the prosecution. And what role should a cabinet minister have in effect in consenting to the prosecution of those that oppose their government's policies? So it certainly marks an attempt to silence protesters in this area. There is, though, a sting in the tail in terms of the Court of Appeal judgment, because at trial we ran what's called a justification defence. We said that it was necessary, in effect, for the defendants to do this because they were acting to prevent death and serious injury to those that were going to be deported. And what the Court of Appeal said was they endorsed a previous judgment from Lord Hoffman in the case of Jones, a well-known protest case, in which Lord Hoffman had said that acts must be considered in the context of a functioning state in which legal disputes can be peacefully submitted to the courts, and disputes over what should be law or government policy can be submitted to our democratic processes. Well, isn't the problem that there is a failure to consider the lack of those processes in the immigration sphere? Isn't the problem that the Court of Appeal failed to consider is that those processes are simply not present in the immigration sphere? And coming back to what Stephanie has said, the only way that those issues can be challenged is a combination of lawyers taking the cases, but also activists supporting migrants and supporting in all the campaigns that have already been mentioned. And it's only in those ways that the fate of those that are most vulnerable in society can be bettered.
Thank you so much, Raj. Yeah, absolutely agree that the problem is the lack of processes in the immigration sphere, and the fact that protest is so necessary and so effective in this space because of that. And speaking of effective protests, we've now got Ben Smoke. Ben Smoke is a journalist and activist. In 2015, Ben helped found Lesbians and Gays Support the Migrants. And in March 2017, Ben was, of course, part of the blockade as part of the Stansted 15. And we've already outlined what happened to the Stansted 15, and I'm sure Ben will provide more insight into why they did what they did and where we can go going forwards. As a journalist, Ben is a contributing editor at Huck magazine, and Ben has written for The Guardian, The Independent, Vice and Dazed. He regularly appears on LBC and other radio and broadcast platforms, commenting on current affairs and politics. And Ben is also writing his first book about the Stansted 15 trial, which I'm sure everyone will be highly anticipating. So Ben, I'll pass over to you.
Thanks so much. Thanks for having me and for reminding me about the fact I have to write that book still. I'm really, really honoured to have been asked to speak tonight, particularly alongside so many incredible speakers and thinkers and campaigners within this area and this particular kind of intersection of campaigning and the law. And so I'm probably not going to take up my full time because I'd rather listen to them, frankly, and also kind of want to hear your questions. But I think a couple of kind of points that I wanted to go around was, firstly, I guess kind of talking a little bit about the experience of being, one of the 15 and being on trial. And Raj kind of set it out in the sense that we expected this kind of very regular run-of-the-mill kind of charging, very short, comparably, trial in the magistrate's court, not a huge life sentence hanging over our hands, the likelihood of it being kind of wrapped up by Christmas 2017 and then crack on with our lives. And we are sat here kind of for 4 years, 5 years, how many years it is since it happened, having just got the appeal, still waiting for the final kind of green light from the CPS as to what they're going to do next. Still kind of sitting here unsure of that. And I think that it really kind of shows how unexpected the whole thing was. I remember the first time that we got the email telling us that they were considering upping this charge. I was like a couple of days out from going to Glastonbury that year, and I remember being less than sober in a field at the festival, talking to some friends about it, and it was so inherently hilarious as a concept, as a prospect, that they might bring this legislation against us. They might bring charges against us. That it was funny. It was incredibly funny, and we were laughing about it. And obviously, that laughter stopped quite quickly after that. When a few weeks later we were told they are actually going to bring this, and actually this is quite serious, and oh God, we might go to prison for a long time because of this, and there's no precedent of them doing this. I think it's interesting to kind of think about why it is that they chose this moment. To a certain extent, it is absolutely because our action, although there have been previous airport actions that actually were kind of more intrusive in certain ways. They weren't on, as we were, a remote part of the airport. We weren't anywhere near runway. It was very, very centered on that one singular plane, that one singular flight, and stopping that. The other previous actions have gone on to runways to shut down, with the express intention of shutting down that runway and or the entire airport. And they have been charged with, as Raj kind of laid out, that aggravated trespass, etc. So, the reason why we were chosen, we were singled out, is potentially because it kind of came after a few of these actions, and the state were getting a bit pissed with it, because actually ours was markedly different in that everything that had gone before majoritively had been based around climate justice. The BLM action at City Airport, which was 2016, if I remember correctly, I'm sure someone will correct me on that if I'm wrong, was very much about climate justice and the fact that the climate crisis is a racist crisis, but again, centered around that. And this was a direct attack on the government's hostile environment, on the government's kind of keystone policy, actually. So you kind of have that. And actually then if you draw out and you look at what's been going on for protesters and for protests and for demonstrators over the past kind of decade of Tory rule, it fits this escalation of the government very much feels that human rights are an inconvenience, feel like protesting rights are an inconvenience. They'd really rather not have to engage with them. Theresa May, when she was Prime Minister, was gagging to get rid of the Human Rights Act. We've kind of seen it progress from, if you remember back in 2010 with the student protests in Parliament Square and various different prosecutions that were brought, malicious prosecutions actually, I'd say, that were brought against various different people who were actually injured by police there, and then were then charged with various different kind of violent offences. The way that played out and the way that those trials kind of kept on going was very much a blueprint for what we're seeing now. So our case happened, and the continuation of that and the pushing of that. And as Raj kind of just very much laid out, it was laughable. It was utterly laughable to sit there in the dock and to hear the kind of nonsense that the prosecution were coming out with, and to do the same in the Court of Appeal. It was kind of a bit embarrassing to watch them, and to be like, are you actually genuinely, like, no harm? You're stood up in one of the highest courts of the land, and you're trying to make the argument that a football is the same as a bomb. And it was kind of that nonsensical kind of dogmatic approach to absolutely they will win this case. It takes place within a much wider crackdown. You look at the crackdown that happened to XR during the October kind of uprising, where the Metropolitan Police implemented public order offences to stop any form of protest within the City of London under an XR banner, which was then ruled to have been ultra vires, be a far overreach of both that singular offence was meant to be, and also the police's power and the power of the Home Office. And so this is kind of the backdrop, I think, to all of this, and to the increasing frustration of the rhetoric. If you just look at the way in which over the past year or so, we've seen activist lawyers, we've seen lefty lawyers, loony lefty lawyers, that's continually sort of built up as Brexit has been done and is no longer a kind of touchstone for people to galvanize a popularist right-wing vote around. They've sort of sat there and thought, okay, well, what is it that we need now? What can we do now? And what we've seen is this pivot to human rights. We've seen a pivot to European Convention on Human Rights. Farage just the other day released a video putting the European Convention in his crosshairs. And this is all sort of leading up towards a direct attack on those human rights, which, you know, there are lawyers in here who can, and academics who can speak at much more length and with much more detail about the various limitations of those rights. But what we have, we absolutely need to defend. And I think that, you know, what we're seeing, what we saw with the Stansted case and what we've seen with the brazenness of the Home Office and their, as was laid out in terms of their housing of people in army barracks, you know, the stuff that they tried to get away with in terms of Glasgow over the first lockdown, and the horrendous conditions that some of the most vulnerable people in our society were forced into and were housed in. They are confident. They are overly confident, and the Stansted kind of victory is a minor setback for them. And I think that that's something that I really think a lot about, is that we are kind of just starting this fight, this new phase. We're just beginning to have to face up against what is going to be a direct assault on all of our rights. And I think that we've been seeing it, you know, building up in terms of protest rights. We're seeing it building up in terms of the rhetoric around lawyers and campaigners have been intervening with deportations, which are blatantly illegal, even within the incredibly draconian set of laws that we have at the moment, and in terms of broader rights. And I think that that's something that this sort of intersection is why it's so interesting, it's why it's so important, and it's why we kind of all need to come together and fight. And I'm kind of going to leave it there because there are much better people to speak coming forward. But thank you again so much for having me.
Thank you so much, Ben. Yeah, absolutely agree with everything that you've said. And I think it leads us quite nicely on to Luke, who's going to build upon some of those thoughts that you've put out there in terms of how we can actually strategize going forwards, and what the limitations potentially are. So I'm very excited to have Dr. Luke de Noronha. Luke is an academic at UCL. He lectures on race, ethnicity, and post-colonial studies. Across his research, writing, and teaching, Luke is concerned with the relationship between racism and the government of mobility. His work provides critical interventions into debates surrounding race and migration in the British context, and he's particularly interested in connections between the legal production of illegality and processes of racialization between the law and racist culture. To examine these questions, he's focused on the UK's deportation practices, and his book, Deporting Black Britons, Portraits of Deportation to Jamaica, was published in September 2020. Luke has also produced a podcast with deported people in Jamaica called Deportation Discs. And he's also working on a co-authored book manuscript with Gracie May Bradley from Liberty titled Against Borders Towards the Politics of Border Abolition, which is due to be published in spring 2022 with Verso Books. And another book that he co-authored was recently published with Pluto Press, Empire's Endgame, Racism and the British State. So Luke, very excited to hear from you, and I'll hand over now.
Thanks so much for having me, and great to be on a panel with everyone here, and to follow Ben, a friend and comrade. So I was going to give a bit more of a historical, theoretical overview, situating some of the stuff about Stansted 15, but then as I came to write this afternoon, I just started thinking more about a different question and thought, if that's what I'm thinking about, maybe that's the more interesting thing to talk about. Which was, we know the Stansted 15 action, we celebrate it, and we know of the 11 people who were booked on the flight who still remain with us in the UK. But I was wondering, why do we celebrate it? What about it should be celebrated in particular? So I went down the thought experiment of a kind of good immigration lawyer who's self-involved, saying that while this action, and this is obviously a straw man, but while this action, prevented 11 people, since that time, my firm has prevented more people than that from being deported. And this same self-involved lawyer then says, after the Stansted 15 action, the Home Office moved their flights to militarized context to Brize Norton, which makes it hard to claim this as a model for future resistance. And that, what the Stansted 15, the 15 individuals were put through, made the idea of that sacrifice even more stark, which of course was part of the reason the CPS took the line they did. And they might say that legal work has a structure and funding and organization, therefore lawyers do a good or better job at stopping deportations than activists. And I realize this position is ridiculous because none of the lawyers who do the good work think this way. And Zara, I think you introduced the whole event with that very set of questions in mind about the relationship between the two. But it does remind us of the obvious point that the Stansted 15 action was about more than those 11 people. And I wanted to think a bit about that, about what that more is. Clearly, the act of resistance holds a different kind of space politically and culturally for us, and is afforded a different value by radicals of various kinds. And perhaps it's because it's recognized as a symbol, a gesture, and an opening in the way that good legal work is not or cannot be. Protests and direct action are forms of extra legal politics. They prise open the gap between the law and morality. When people, a collective, a group of friends or comrades chain themselves to wheels of a deportation flight, they say that the routine enactment of the law is a form of unconscionable violence. They say that charter flights are wrong because all forcible expulsions are wrong. And we should all see, the public, various publics, the ugliness and brutality of what often goes unseen and uncommented upon, but in our names. In other words, direct action like this can subject existing laws and state practices to scrutiny and make them political again in spectacular ways, and try and open up political space. And of course, there's a romance to it all as well. The bravery, risk and sacrifice, the moral refusal, not in my name. And let's be honest, the planning of the mission, the fence cutting, and precisely the law breaking. The transgression of the law holds a seductive power for all of us, not only the left. Everyone's paused. Can you still hear me? Good. Okay, thumbs up. So the transgression and the criminality holds a kind of seductive power for us, I think, and not only on the left. Anyway, the point is that we need to defend the right to protest and defend direct action, because we all know that political change doesn't happen step by step, case by case, or reform by reform. Sometimes people show us with their bodies and their hearts just how rotten this world is and how it could be otherwise. Actions like this inspire people, and I think we need to feel inspired if we are going to win and keep going. The despair of the moment threatens to swallow us whole, and political change relies on us feeling our collective power in our bones. That said, the legal challenges might be the most immediately effective way to prevent deportations. When I meet people facing deportation, I try to find them a good lawyer. I don't try and break them out of detention, although we might be in a better place if that were possible. Lawyers can win cases, and that's what individuals facing deportation want more than anything. But it is a truism that the law forces us to speak in the law's terms, to comport ourselves to the immigration policies that are themselves the very problem we're up against. Getting people off flights through legal action is definitely part of the struggle. And clearly the so-called lefty lawyers try to think strategically about the litigation they do, about case law, and are in conversation with one another like this is part of. But the limits are real. And with the government like this, they might be becoming even more real, even more restrictive, following, as Ben noted, the UK's departure from the EU, the attacks on human rights activist lawyers, and judicial review. As someone who's read many deportation cases, I know that the work of immigration lawyers is difficult, not only legally, but also emotionally and in a way ethically. Because the system is so degrading, so dehumanizing, and people facing deportation, the clients, are forced to make a case in a way which diminishes their humanity. And lawyers have to help with this very process of turning a life into a case. And while this is obviously crucial and has a clear strategy, it is not and should not feel like an easy thing to do. In deportation cases, immigration lawyers find themselves gathering evidence of people's intimate lives to try and prove something like love, relationships which are genuine and subsisting in the Home Office's terms. Or they find themselves referencing OASIS reports from probation officers, which are highly questionable to say the least, to argue that their client is in fact low risk of reoffending. Or they have to prove that separation from children would be unduly harsh, as though that's the way we think about relationships, and that the child wetting the bed really is because their father is detained. And then they need to provide a social work report which provides evidence of that thing called real family life. And then the client goes through this very humiliating process in court, where the judge forces them to again atone for their criminal and immigration history, their endangering of British society, and they stand when the judge enters, yes, Your Honour, no, Your Honour, and then try to verbalise why deportation would destroy their lives. I'm not saying this to make some cheap point about lawyers being complicit in the system, as though there could be an effective political strategy that involved staying pure and untainted on the outside, as though litigation doesn't matter and we could somehow just scale up Stansted 15. That's untenable and unhelpful. But I do want to register that the lawyer-client relationship doesn't feel great. It doesn't warm the cockles of the revolutionary heart, and it does not suggest radical alternatives to our nightmarish present. Good legal work, in my limited experience, is messy, compromised, difficult, tedious, and incredibly useful. And hence we return to that fateful evening when 15 protesters chained themselves to the deportation plane. The Stansted 15 said to the people on that flight, "You should have to stand for no judge. Fuck you, Your Honour, not in my name." What they showed, and maybe what they felt, was the force of something like collective power and resistance as more than a platitude. Something that lawyers, often underpaid and overworked, staying up all night to file a JR, might not get to feel. And I think that's important to say, because I think people think lawyers are more well paid and in a better position than they are, from the experience that I have with those who do a lot of the hard work involved in this. I think the challenge is to value both these kinds of works and find ways to join them up strategically, which I guess is part of what this event is about. And I don't have all the answers. I don't have the answers, but I'm very sure this is the question. Okay, so some final reflections of things to discuss that build on actually where Ben ended, which is, I was thinking about Stansted 15. So what of the Labour Party? Now, Stansted 15 in a way, had the ear of Corbyn's Labour Party, in the sense that they promised to end charter flights in what to me seemed like a direct response to the action. And the comms strategy and all of that related to a particular moment, which is no more. Forensic Kia is playing the game of focus grouped red wall patriotism, while the Tory party maintain their mandate despite everything that's happened in the last year, and Priti Patel as our Home Secretary with her cartoonish evil and knowing cruelty. How does that change our strategies and possibilities? Secondly, another point I was thinking about, some people online commented on the fact that the Stansted 15 were mostly white and university educated, which they could say for lawyers too, which was a fairly lazy comment, given that that was obviously part of the strategy. Anyone recommending 15 working class Black, Muslim or migrant activists to do the same would be rightly denounced as politically naive. But I do think that if we can critique lawyer-client relationships and the power relations therein, then we can also do some soul searching about activists and illegalized migrant relationships, which of course people do in the movement. And clearly we need to think about how to build other constituencies, or bigger or broader constituencies committed to dismantling borders. And here I'm thinking of the potential of people following Asime Brown's case, people who were aware of Durrell and Darren Roberts' case, 2 people born here who are facing deportation to different countries, and who might follow the rapper Cashtastic, who was removed to Jamaica and found his way back after 5 years. And because I follow these stories and videos and, you know, was on One Extra Talks to talk about deportation, I sense that there are young people who comment on these YouTube videos with support and with a sense of injustice, and with their blame reserved only for police and politicians, not the young men who sell drugs or whatever it might be. And that those constituencies, there's radical potential in them. And I know that this is what people thought around Grime for Corbyn and other things, where there was, how do we build urban new constituencies of left-wing politics, because we can't do it on our own. Finally, and perhaps most importantly, there is the self-organization of illegalized people themselves. So we can talk about Stansted 15, but during the same period, roughly the same period, I think, was the Yarlswood hunger strikers, which was incredibly impressive and articulated a set of very sophisticated demands, which did not play into any of the good migrant, bad migrant stuff, as did the Stansted 15 make a deliberate point of not playing into. So that was incredibly important, and it involved also engagement with activists who were on the outside and who were citizens, and those who were currently being detained. And then there are, again, a kind of constituency in waiting as young people who are undocumented or precarious, because of course, if this country has many non-citizens and precarious migrants, then they are overrepresented among the young, probably increasingly so given Brexit, and specific groups will struggle to regularize. So how do we connect those young people who might have different kinds of common sense about the police and about politicians, or who might themselves be undocumented or friends with people who are undocumented or precarious, and how can we make that overlap with the energy of the many young people who came out for Black Lives Matter and who are talking in the language of abolition? Whether the left and all the people here and all people committed to challenging state violence can engage with and encourage these nascent constituencies and help them flourish, that might just be the question of whether we win or lose. I'll leave it there.
Thank you so much, Luke. Really, really helpful reflections. And I think, absolutely agree that we need to think more around sort of the language of abolition and how we incorporate that into sort of legal and kind of activist endeavours. And I think from what you were talking about in terms of self-organisation, I think that leads on to, I'm sure, what Zita will talk about in terms of the work that she's been doing for Jamaica 50 last year and countless other anti-deportation campaigns. Zita is an award-winning human rights and equality campaigner, trade unionist, community activist, visual artist, curator, poet, author, and vocalist. She is co-founder and national chair of Barrack UK, a founding member of BAME Lawyers for Justice and BME Lawyers for Grenfell as well. She was elected to the TUC Race Relations Committee, Women's Committee, the General Federation of Trade Unions National Executive as well. She was also the National Vice President of PCS Union and is also the Joint National Chair of Artists of the Artists Union England. Zita's played a leading role in campaigning for justice for the Windrush generation and against detention and deportations and for migrant and refugee rights. She was a national coordinator of the Windrush Day of Action and also coordinates humanitarian aid distributions to people who are displaced. She's also part of the UNESCO Coalition of Artists for the General History of Africa and the curator of the Roots Culture Identity Art exhibition, an annual exhibition which is now in its 10th year, established in the memory of Stephen Lawrence to provide a platform for young Black artists. Zita campaigns for equality, freedom, justice, and human rights and through art and activism. So very excited to hear from you, Zita, and thank you for joining us.
Thank you, and thanks for the introduction. Greetings, everyone. So the issue of deportations is something that I've been campaigning on for many years, and particularly in the early period of doing that was around people who had fled their country of origin because of persecution, and then subsequently supporting people who have had to flee their country because of a combination of the impacts of climate change, poverty, conflict, and persecution a lot of the time. And so when I first started campaigning around the issue of detention and deportations was actually way before the so-called Windrush scandal was described as such. And Barrack was founded in 2010, but in 2012 we co-founded the Movement Against Xenophobia because the immigration bill that was coming through was going to have the impacts that we've now seen for the Windrush generation. And we were warning then about what those impacts would be and trying to prevent that legislation from going through. It did go through. We had a shift to the right of all political parties. It's largely supported with the exception of a handful of MPs. And we were warning then that you know, within our communities, if there were people that thought that there may be an issue around the immigration status, not to wait, but to get advice, but also trying to put pressure politically around that legislation and the impacts it would have, and exposing how it was creating effectively like an apartheid-like state, with blocking access to essential services like the NHS, for example, and warning that it wasn't just going to impact on those people who are new migrants to the UK, but also people that have established communities who have been in the UK for a long time. And in 2016, we became aware, literally days before, of a mass deportation charter flight to Jamaica, where there were 50 people booked on board. And we quickly started to campaign with like days' notice around this issue. And that's where the Jamaica 50 hashtag comes from that first particular flight that we started to campaign on. And I think that flight was a shock to the system for a lot of people, because we were able to raise wide awareness, but actually in terms of getting support, we were able to get support, legal representation for some people, but the turnaround of people being detained, then being deported, was really, really fast. And even for the individuals and their families concerned, they didn't have time to process what was happening, let alone know how to navigate the system and get the support that they needed. So we've been campaigning against those flights, and actually on that flight and subsequent flights, we're members of the Windrush generation. And then in 2016 that happened, and I wrote a piece in The Guardian asking, how can 50 people be snatched and just disappear on a flight like that, and nothing's said, nothing's done? You know, it was quite a shock to everybody's system. But it was a couple of years down the line before really the Windrush scandal was exposed and came to sort of proper public attention, and people started to look at what was happening. So the reaction to the charter flights when they're happening, yes, we protest those, and we protest in lots of different ways. And of course, before lockdown, as you mentioned at the start, we also organised the protest in Westminster, in central London, against that flight. But alongside that type of physical protesting, we would be lobbying politicians and organising events in Parliament, and giving practical support to people and advice and information, and trying to get them lawyers and running legal surgeries. You know, a lot of the lawyers in BME, Lawyers for Justice, have given up their time to provide legal surgeries with different organisations like the Black Cultural Archives, lending their space for those to take place. Of course, when it came to this charter flight that happened in December, we were in the pandemic, and so we couldn't go out and physically protest. So we took to social media. We had an existing petition against stopping all charter flights. which has nearly 200,000 signatures. So we're able to use that as a communication platform to update people daily and to put out a call out for people to take action. But we were supported by lots of different organisations coming together and individuals, organisations like Gal Them, who asked me to write a piece and then did a model letter and that sort of thing. So it was a mass effort, not just through Barrack UK and BAME Lawyers for Justice, but all of these different groups and organisations. And even now, we haven't had a chance to really properly go through all of the copies of correspondence to MPs. Literally, we were inundated, and for well into January, we were still getting people saying, this is what I've sent to my MP, this is the response I've had back. So mass action, but what we want really is not to have this division, as has already been mentioned, of good migrant versus bad migrant, but we're also making the link to the fact that when the government say these are all hardened criminals, unstable. Can you hear me? Yeah, okay. What the point that we tried to make is, one, that the people who are being targeted for these mass deportations, if you look at where they've come from and why they've come to the UK, there is a link to the UK's part in enslavement of African people and the legacies of colonialism, and that needs to be taken into account. When the government tried to separate people and say, well, these are hardened criminals, they've labelled as such, and we know, and I won't go through the details of lots of individual cases of, setting out, because I think people here know that's not the case. That's what the government did to try and demonise and label and separate those people out. Well, the vast majority of the people came to the UK because of those legacies, but also because of a direct link with the Windrush generation and the fact that they are the children and grandchildren, the descendants of the Windrush generation. They wouldn't have a link to Britain if it wasn't for Britain's colonialism, if it wasn't for the Windrush generation and so on. And I think that that's important because it is this separating out of that group of people and saying they're bad migrants, they are foreign nationals that are offenders. And if we look at lots of people who've been deported, they've been criminalised by virtue of their immigration status, and that included the Windrush generation. But also we've got young people under Operation Nexus who've been deported just because they were stopped and searched, which is part of a racist institutional racist system that we have in Britain, why that's happened, and under joint enterprise, which is now defunct. And so all of those issues need to be brought into the conversation and the narrative about what's really happening, and the targeting of migrant communities, whether they're new migrants or whether they're people that have been here for decades or even centuries. And it is a system of oppression and racism, systemic racism, and we can't separate that out and say it's about immigration policies. It is about racism. And we've seen a lot of noise from institutions and from politicians and governments after the mass protests in the summer because of the horrific racist murder of George Floyd, which was about that systemic discrimination and racism we face, using that hashtag Black Lives Matter and largely tick box exercise approach towards it, but not actually doing anything about that systemic racism in real terms and practice. And what we've seen is huge numbers of reports by the government, commissioned by the government, that say that the conclusion is that there's racism in the UK, but all they do is just commission another report and don't take action, like the lessons learned, Home Office lessons learned, 30 recommendations that still haven't been implemented, and they're not learning lessons. So really, we don't want to be having to react and organise protests when there's a mass deportation. We don't want to see that happening in the first place. And yes, what are the solutions? we're in a really difficult situation with the government we have. So it comes down to people power, and it comes down to us recognizing that all of the people that are targeted for discrimination, we make up the majority, and we need to work together and campaign together and use all the tools at our disposal. Because, you know, under a previous Labour government, they did say, yes, they would do something about all of these things. But we don't have that support at that level. We have individual MPs that support the campaigns that we're running. You know, what we're facing because of the pandemic is horrendous enough as it is. And we saw in the deportation flight in December, no proper measures around coronavirus, no action taken to make sure people were safe and protected, outbreaks of coronavirus in detention centres, one which had to be closed, and even people deported found to have coronavirus when they arrived in Jamaica. But also there's the impact of that deportation on the families left behind, the human rights of the children and the families, and the fact that we're in a pandemic and Black people are losing their jobs disproportionately, contracting coronavirus and dying of coronavirus disproportionately. For that family left behind and the partner left behind with the children, having to try and balance homeschooling, childcare, work when they're in precarious work and frontline work where they're at risk and more likely to lose their job or be furloughed. There are human rights there, and that's increasing and deepening discrimination. So I think we need to make the links between all of those things, campaigning and going forward. This is about racism and systemic racism. It's not just about immigration policies. Thank you.
Thank you so much, Zita. And I think a really great way to end the panel in reflecting on what this is all about and what we are fighting through these protests, through defending the right to protest. It is ultimately these racist structures in which, you know, people are being oppressed, and one function of that is the deportation system. So if you've got any questions at all for the panelists, please do post them in the Q&A box. I've seen a few comments on the chat. And so I thought I'd just start with reading out one of the comments that was on the chat and just putting that to some of the speakers to see what their thoughts are on it. I imagine a few of them will probably agree quite strongly with it. But the comment is, I think framing it as the state's failure to provide a fair immigration system is the wrong way to phrase the question. The immigration system works perfectly well in order to control the flow of labour into Britain. That it is racist, violent and oppressive is a necessary product of a regime which attempts to restrict the right of people to move. So essentially, you know, it works perfectly well by state design. So I was wondering what people's thoughts are on that. So I thought maybe I'd go to Luke and then Stephanie on this question. So Luke, thoughts on that comment?
Yeah, I mean, it sounds a bit like does it make sense to talk about fair immigration controls, or would that be possible? And I think, yeah, I would fall on the line that immigration controls will not be fair, and that what they do is precisely what the comment describes much better than I can. But we're kind of fighting for them to be less bad. We're trying to find weak points. And there are ways we can talk about their strategy around that. And I think there are very different strategies that people take in the migrant sector. So, for example, do you focus on trying to fit more people into particular boxes like refugee or citizen, or do you focus on trying to reduce the state's capacity to use coercive power to raid, detain and deport? And I don't think those strategies it's one or the other, but I think there's a set of questions about which strategies we use and what that might mean for the racist state or racist state practices. But I agree. I mean, I don't think that anyone here would want to be given the task of coming up with a fair immigration system necessarily, especially not when you think historically. But there are less bad ones, and it seems to me that the immigration system has got progressively worse in all sorts of ways, and we need some kinds to build some power so that we can radically transform it rather than just chip away at little bits. I think that's becoming clear increasingly with, as I said, Priti Patel at the helm.
Absolutely. Yeah, Stephanie, I don't know if you had any thoughts on that. I think you're on mute, Stephanie, by the way.
Yeah, well, I think I probably used that phrase, so that prompted the question. And I suppose I was talking about it from the perspective of broad campaigns that arise. And within that cohort of people, and the broader the campaign that there is, then there tends to be a spectrum of opinion about immigration control, whether it's legitimate at all, and whether it should be done in a different kind of way. And that spectrum of opinion is important. But it certainly means that if you're going to have a very broad-based campaign, you will have people who have the view that there has to be some form of immigration control, but it must be fair and it must be humane. And if it's a contradiction in terms, then I can accept that in theory, but in terms of the current discourse, the ability to galvanize people broadly in support of individuals does require you to recognize that compromise needs to be made, because fighting the battle of no immigration control at all is not going to be a battle that we can win. And in the meantime, we have pressing, urgent situations that do need as many people as possible to get behind the campaigns and to do all the different kinds of activities that we've talked about, because I think that's the great message of what we've heard today is there's a spectrum of activity that people can be involved in, and they can be involved in it for different reasons, but each one has an important role to play.
Absolutely. Thanks, Stephanie. I had a question for Raj, actually, stemming out of what he was talking about in the Stansted 15 case. And so in light of what the Court of Appeal said about justification defences, I was wondering if he had any thoughts on how to bring in this sort of wider immigration context, things that sort of Zita mentioned, even the sort of broader context of institutional racism, most effectively when defending protesters in the criminal courts in sort of anti-deportation cases. How can we bring it in, if at all?
I think it will remain difficult. I think on a broader point, there is a difference in interpretation on the Court of Appeal judgment. I do not think that it rules out justification defences in their entirety, because the Court of Appeal reviewed the evidence and considered that the evidence that the trial court heard did not meet the test of justification. So the first point that we should all take away is, if that's good enough for the Court of Appeal, it should be good enough for all first instance tribunals, and that's the argument that we should be making throughout now, that the Court of Appeal is saying, in effect, our interpretation is that you must hear the evidence, and that once the evidence is heard, a determination can be made as to whether a defence can be left to the jury. I think in terms of how we then get to the broader point that there is a democratic deficit, in effect, there's a deficit in the state in relation to the immigration system, we may now need to consider more expert evidence in relation to that. We've been fearful of doing that for provoking rulings to rule out the defence. But if the real issue is, the Court of Appeal says, you've got alternative mechanisms to draw these disputes to the attention of the state, then we have to try and show that that's simply not possible. I think it's a risk in each individual case, and it will have to depend on the circumstances of each case.
Absolutely, yeah, I think that's really helpful to think about tactically. Zita, I did notice there was a comment in the chat that I thought you could perhaps speak to. Someone said, I believe that under an imperialist state, people will be far from protected or given the justice they deserve. And so I was wondering what your thoughts are on that comment, and how we can work, if we can, within the system and the structural oppression we're within, to fight for justice, which is obviously a huge part of the work that you do.
Yeah, so I agree with that. And I think that the issue of racism is actually a global issue. And so, we need a global response to this and global movements. And we are organisations I'm involved in, like Barrack UK, are connected, with different groups in other countries, and there is a bit of a movement around these issues. For example, around reparations, there is a reparations movement because of enslavement of African people. So we do have to have a global response to this. And if we look at the Black Lives Matter movement, that's a global movement. It's not just about a Black Lives Matter organisation in the UK and in the USA. It's about a movement of people who are saying enough is enough. We've had enough of discrimination. And I think when we look at what's happening in the USA and what happened under Trump and what happened to Mexican community there. I was in a meeting with people in the USA a couple of weeks ago who do similar work to BAME Lawyers for Justice and Barrack over there, supporting individuals and campaigning on these issues. And when I was describing the Windrush scandal and the deportations here, they were saying that it sounds like I'm talking about the USA. It's a different group of people, but exactly the same things that they're facing. I think we need to do more to join up on these issues and have a mass mobilization of people across the world that work together, because we're all doing similar work on similar issues, but we don't always come together and we don't always strategize together. And I think we spend a lot of time reacting to things as they happen, understandably. We all have other lives and try to juggle lots of different things as campaigners and activists or lawyers, our time and energy can be zapped just responding when there is something like a mass deportation flight. And then we don't have enough space and time to sit down and come together and organise and come up with a strategy and sort of progress that and take it forward. And that's what we need to do, I think, going forward.
Absolutely. Yeah, thank you so much, Sita. We've got a question in the chat that I'm going to ask Ben to comment on. The question is, do you think that linking directly with climate change, non-violent direct action / disobedience activists may help or hinder?
That's a good question. I think in the particular specific individual instance of Stansted 15, it very much helped, because I helped set up and found Lesbians Against Deported Migrants. We did a lot of, I would like to think, really good solidarity work. We did a lot of fundraising, a lot of kind of organizing of community events. We did a couple of direct actions, but fundamentally that our kind of knowledge of direct actions was limited pretty much to just kind of glitter and dancing, and neither of those are that helpful when you're trying to stop a deportation flight. So in terms of like the actual specific knowledge to be able to safely execute the direct action that we did, then absolutely. And I think that more and more what we should be looking to do, and I think what don't want to put words in the mouth of it is a question of scale and enough glitter. I don't want to put words in the mouth of other members of the 15, but I know that those who kind of originated from a climate background were seeking to join those dots up and to link between the fight for climate justice being a fight for social justice, the fact that the climate crisis is a racist crisis, the fact that what we are seeing, the impact of the climate crisis is already happening in across countries in the global south. It's already seeing various different movements of people, and will continue to do that. And even here in the UK, we saw, I think it was December, the first instance of a coroner's court ruling that poor air pollution was directly affected the death of a 9-year-old black girl in southeast London, and we will continue to kind of see that. And so it's incredibly important to link those things up. I think that there is a lot of work to be done, particularly within the climate movement, but also within the migrant justice movement to not just trying to link those dots, but to make space and to allow the voices of those at the sharpest edges of everything to not only be heard and to be platformed, but also to lead and to set the direction. And I think that there's a lot there that needs to be done, and a lot of work that I particularly, and a lot of the other 15 and a lot of other parts of the movement can definitely be doing. So yeah, that was a kind of rambly way of answering that.
No, thank you so much. Yeah, definitely agree. We've got a question. Well, there are two questions I think I'm going to put to Stephanie. One is any comments about Shamima Begum's upcoming case in the Supreme Court, I guess, in the context of what we're discussing. And someone else has asked for Stephanie to elaborate on her point about how alt-right people using some of these direct action methods to foster hatred can be addressed. So balancing the right to protest, but also fighting against racism and harassment.
Yeah, on the Shamima Begum case, I think the important link here is that the primary issue in her case is about whether she can have a fair trial from the camp in Syria, which the answer is no. And the question, therefore, is does that mean that the decision to deprive her of her citizenship was unlawful? That's the key issue that the court are going to rule on. They won in the Court of Appeal. Whether they can uphold that decision, we'll have to see. But it certainly would mean that if she does lose, there's no prospect of other deprivation cases where the person is outside of the country and they can't have an effective remedy succeeding. I think what's perhaps more of an importance about that case for this debate is the very fact that she could be deprived of her citizenship, even though she was a person born in the United Kingdom, had no Bangladeshi citizenship, although of course her family did have those rights. She had it in principle, but not in practice. And so this ability to take away your legal connection and status to a country is obviously a key element in the deprivation provisions. That's there express, and it is being used against those who have an immigrant background. So it is being used in an obviously discriminatory way. But similarly, the example of the Windrush cases were individuals who had the right of abode. They had legal rights derived from the law that going back to 1948 that meant that they were legally here, entitled to be in the UK. And there were also prohibitions against deportation, but they had no practical effect in preventing both denial of citizenship, deportation, and in some cases, detention. So that's the common feature between the two, that there is no vested, recognised entitlement to citizenship if you come from an immigrant background. And that is obviously at heart an integral racism within our immigration system that has got enhanced over time. So that issue is not going to be resolved in the Supreme Court, because that a part of the case where she about having an alternative citizenship, she lost and couldn't pursue. The other question that you asked about far right activists, I suppose one thing to make the point about that is that despite the fact that these groups have been organising overtly racist and Islamophobic protests, which would constitute harassment and aggravated offences, whilst there's been some prosecutions, there certainly hasn't been the sorts of measures that have been taken against other protests. The contrast is stark, and clearly you have a situation where highly vulnerable people are then the target of extreme racism, and it is in the context of a lot of very frightening social media activity, where commentary on gassing and treating people as less than human, all of that is a wider context that's going on. So there's a marked lack of state intervention to deal with that. And I think we have to draw a significant distinction between protests that is racially motivated, creates hatred, generates racial hatred, and has as part of its purpose harassment and intimidation. That crosses the line, and it's not legitimate protest, and it needs to have some action taken, but the state has failed to do so far. One thing that it has generated is counter demonstrations, and so that is where you get police involvement, because there have been clashes, and then you do get the police arresting some people. But otherwise, it's been a hands-off, stand by and let this happen sort of strategy that's only really come to an end because of the COVID regulations. Otherwise, it would still be going on now.
Thanks, Stephanie. Yeah, I think that's really helpful. And I think another kind of perspective to add on that as well, there's some groups that have been doing some really interesting work on sort of having an abolitionist approach to hate crime. And DICON, which is an organisation for East Asian diaspora in the UK, has been doing a lot of sort of work and training around this. So that's maybe another perspective to consider as well in terms of how we approach the alt-right protests that are going on at the moment. I've got a question for Luke. So what do you think we should expect in terms of the government simply changing legislation in response to court rulings it doesn't like, and how can we fight this?
Yeah, well, they might do that, and that's the limitation of winning legal cases, I guess, which is why at different points you fight for different kinds of things against, or for a less bad government to struggle against and under, or which was 2019 for me, or at this point maybe doubling down on kind of trying to build in the longer term radical constituencies, precisely by thinking about various social movements. If a lot of social movements found themselves in Corbyn's Labour Party and now have dissipated back and depressed and trying to work out what to do given the pandemic, there has to be, exactly as been pointed to, anti-racist, anti-police mobilizations connected to borders, climate movement, as Ben put it really eloquently, connected. And I mean, same old thing you would say for all forms of resistance to repressive governments, is that you need to build power of different and opposing social forces and groups and organizations so that they can put pressure or get a less bad government in, so that the legislature aren't making such horrendous laws. But at the moment, you can't not fight because you fear that that they'll just turn around and make it even worse and punish you even more. And that we have to kind of ride the ups and downs of it and keep going and thinking together strategically about what makes sense as a particular fight. But I think that that's a real threat, and it's happened before and it will continue to happen.
Absolutely. And then there's one question as well, which is about anyone who knows the answer, please do jump in. Is there a simple way of finding out how many people are facing possible deportation from the UK at any one time? Does anyone know the answer to that? No.
The answer is no, I think.
Yeah, which is probably part of the problem.
Yeah.
You won't know at the time. They do collate the statistics on a yearly basis. You'll get those numbers.
Yeah, exactly. And I think one of the things that was, oh, sorry, go ahead, Luke.
But also it depends what you mean by people who are facing possible deportation, because by saying facing possible, you kind of mean a lot of people there. So, I mean, arguably any migrant in violation of any immigration restriction is deportable, and that number is unknown, and it depends on all the children who have unknown state. It's really hard to say, and it depends what the government decides, what the Home Office decides to do and focus on. So yeah, I think that number's huge, but also not real in the sense of who's going to realistically end up in a detention centre.
Absolutely, yeah. And I know that when the Jamaica 50 Charter was going on in December last year, just from kind of work I was doing with Barrack and Movement for Justice at the time, it was very hard to find out what was going on for people, in the hours before the charter flight was due to take off, and that makes it even more difficult to then coordinate protests as well as securing legal representation. Zita, I don't know if you had any comments on the kind of inaccessibility really for people to contact people for solidarity and legal representation when they're, you know, hours away from a charter flight?
Yeah, it's extremely difficult for the families and the individuals concerned, particularly this time round in December. People were limited in even trying to get legal representation because, for example, the rooms where they can access office facilities to try and do some research on a computer or use the telephone were closed in some centres because of coronavirus, yet they didn't test people coming in for coronavirus or care about them having coronavirus in their cell. That's another issue. So it was really hard, and often it would be because of the campaigning we were doing, either because in some cases this has happened to them 2 or 3 times. So there'll be people that already knew us and will get in touch because they've got our details already. Sometimes it would be family members, partners, for example, or nieces or aunties or whoever it was, just reaching out to us on social media and saying, we're in this situation, we don't know what to do, we don't have an immigration lawyer. You know, if they did before, it was when they were threatened with deportation before, or we think that we might be targeted, we haven't yet, we don't know what to do. So it was really difficult. We were trying to get representation for those individuals and saying the most crucial thing is you need to get legal advice, you need to get legal representation, explaining what the process and system is and what needs to happen between this small space of time. But what's happening is people are being taken and given a really short turnaround before they're actually deported, leaving very limited time to even, you know, orientate themselves and get their heads around what's happening to them, and then trying to navigate the system when they're not used to it. And, you know, lots of families don't want the public exposure. They don't want to be out there in the media. You know, they're really worried about that and anxious about it. So one of the things we did was to anonymize stories and use voices. I worked with a filmmaker, you know, to use some of my art with somebody's voice to expose the real impact on what was happening. But obviously in the short space of time where it's only a week or 2 weeks, you haven't got much time to do that. And I know there was action in the European Court of Human Rights around time limitations and how short periods people were given. And that highlighted that, including the Windrush people that were targeted for deportation, would not have been given the correct notice period that they're entitled to before they're deported, but they're cutting it finer and finer, it looks like, on purpose, because it's a tactic the government are using to try and get people out quickly.
Absolutely. I think, Stephanie, did you want to comment on that quickly?
I was just going to come in and say that that the policy that the Home Office have been operating, so-called removal windows policy, was declared to be unlawful because it wasn't allowing people to have sufficient time to access justice. And that policy has been in place since 2015. So that's 6 years of situation where an unlawful policy was depriving people of the right to get in before a judge and prevent removal.
Absolutely. There are a few other questions on the Q&A, but we've gone a bit over, so we might not have time to get through all of them. I just wanted to pick up on one question, but that I thought I'd just kind of throw out there for people to take away and think about. Someone has commented, sort of following on from the conversation about joining with the climate justice movement, and organizations have had sort of long sustainability agendas and policies, with the majority of local authorities declaring climate emergencies irrespective of political leadership. And so there's a sort of idea that in terms of the local and wider importance and influence and impact of organizations and political institutions introducing specific anti-racist policies. So I guess that goes to the point about sort of taking learnings from what the climate justice movement has done and imposing it into this context and thinking about sort of local groups. And I think that's what Stephanie was referring to at the beginning as well, in terms of thinking on a kind of local level, but as well as what Zita was saying about, you know, thinking internationally as well. We need to operate on all those levels in order to get anywhere. But yeah, I mean, that's all we have time for today. Thank you so much, everyone, for joining. And thank you so much to all of our brilliant speakers. I hope everyone's found it insightful. We've had some really helpful theoretical and practical insights on the law, policy, and also strategy going forwards. And I think if you take anything away from this, I think what all the speakers really highlighted was just the importance of collective power, and that this is going to be the only way we can really sort of dismantle the racism of the British border. So if that's one thing you take away, please do kind of reflect on that. Most of the speakers here have Twitter, so do follow them and engage with the conversation after this event, and we will share all the materials and the recording with you as well in due course. So thank you for coming, and thank you to all the speakers again.